Our next rule of construction is the golden rule. This rule can be stated as follows. Where the words have two or more meanings in any given legislation, they should be given their plain and ordinary meaning unless any such meanings produce absurdity or repugnant consequences. In such a case, the meaning that is not absurd will be preferred to the one which may be absurd. Sounds simple, but let's see how simple is this. Despite the literal rule and the judiciary's will to limit itself to the plain wording of any enactment, there may be the cases where avoiding manifest absurdity may only be in consistence with the parliamentary instruments and enactments under the consideration of the court. The golden rule does not go beyond avoiding absurdity or inconsistency with the enactment and is an adaptation of the literal rule in a way. The rule simply allows the courts to prefer a sensible meaning, a more sensible meaning to an absurd meaning where the word or term carries both meanings. The golden rule has been stated in the case of Gray against Pearson, 1857, in the following words. The grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some absurdity or some repugnance or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the words may be modified so as to avoid that absurdity and inconsistency, but no farther, per Lord Wensleydale. In another case of Jones against Director of Public Prosecutions in 1962, Lord Reid stated, "It is a cardinal principle in all statutes that you may not attach to a statutory provision a meaning that the words of that provision cannot reasonably bear. If they are capable of more than one meaning, then you can choose between those meanings, but beyond that you must not go." In the case of Kurtz and Cow against Inland Revenue Commissioners, Lord Reid stated, where a statutory provision on one interpretation brings about a startling and inadequate result, this may lead the court to seek another possible interpretation which will do better justice. Lord Reid, on another occasion, in the case of Luke against Inland Revenue Commissioners, stated the same point as follows. It is only where the words are absolutely incapable of a construction which will accord with the apparent intention of the provision and will avoid a wholly unreasonable result that the words of the enactment must prevail. So in light of all these decisions, we are going to see how the interpretation of the golden rule is carried out. In view of the statement by Lord Reid in Jones against DPP, golden rule has been frequently interpreted narrowly. However, given the approach of the court in departing from the literal rule, the golden rule has been interpreted in a narrow as well in a slightly wider sense, really depending upon the needs of the circumstances. Let's look at some examples of the golden rule applied by the courts in different cases. First case, R against Allen, 1872 case. The relevant section for the interpretation purposes is section 57 of the Offences Against the Person Act 1861, which reads as follows: "Whosoever being married shall marry any other person during the lifetime of his spouse shall commit the offence of bigamy." If we look at the literal meaning of the words used in this section, it is impossible for a married person to marry. If someone is legally married, he or she cannot ever commit this offence, ever. However, the judges interpreted the word marry in the following sense. That is, to go through the ceremony of marriage. Cases of Jones against DPP and R against Allen were examples of the narrow application of the golden rule. In both cases, please revisit if you need to, the words had more than one meaning and one of the meaning was applied. Following are the examples of the application of the golden rule in a wider sense. Case of Adler against George, 1964. In this case, the defendant had obstructed a member of Her Majesty's forces whilst he was inside the Marham Royal Air Force Station. Section 3 of the Official Secrets Act 1920 stated that a person will be guilty of the offence of obstruction if it takes place in the vicinity of any prohibited place. The defendant sought to use the literal meaning of the legislation to avoid being guilty of an offence. He argued that he could only be held guilty of an offence if he would be in the vicinity of the place. He argued that he was on the station itself when the incident took place and that he could not be said to be in the vicinity of the place. The defendant was convicted in this case as the courts decided that the Royal Air Force Station was included in the wording of in the vicinity of any prohibited place. The defendant was on the base, and in the vicinity includes on or near the station. Another example, Resig, 1935. In this case, a son had murdered his mother. According to the law, the son would have inherited his mother's residuary estate under the intestacy rules and in the absence of any will made by the deceased. The relevant law, that is Section 46 of the Administration of Estates Act 1925, had no ambiguity in that the son would be entitled to the estate as an issue of his mother. Issue is a technical term for the inheritors, like son or daughter. However, the court held that since the son had murdered the mother, he should not have been entitled to her estate, as this would produce obnoxious results. It can be said that the court in this case effectively extended the meaning of the legislation by excluding the murderers of the estate owners from their entitlement to the inheritance of the residuary estates. Here is another example of the application of golden rule, where the statutes have been interpreted to resolve obvious drafting errors. In the case of Inco Europe Limited against First Choice Distribution, the House of Lords, now Supreme Court, had allowed for the words to be added to statutes in order to resolve obvious drafting errors. Lord Nichols stated the court must be able to correct obvious drafting errors. In suitable cases, in discharging its interpretative function, the court will add words or omit words or substitute words. This power is confined to plain cases of drafting mistakes. The courts are ever mindful that their constitutional role in this field is interpretative. They must abstain from any course which might have the appearance of judicial legislation. A statute is expressed in language approved and enacted by the legislature. In this case, the Arbitration Act 1996 did not contain a right of appeal from the High Court to the Court of Appeal. The court added this right to Section 9 of the 1996 Act. We will now look at the mischief rule. See you in the next lecture.